In this installment, Candace Cooper is being interviewed by Jack Sariva discussing tenant departures and public record cleanup.
Hi Candace, why do we care about post-tenancy cleanup? Is it that important to deal with title and off-title matters after a lease ends?
Public record cleanup after the end of a lease is important to landlords and property managers who want to ensure that future negotiations with tenants and other dealings with the property, such as sales and financings, are smooth. Keeping an eye on title and off-title matters in the post-tenancy period helps landlords and property managers clean up messes in the public record without the time pressure of a closing. As you can imagine, as time passes, and particularly where a third party is involved, it can be increasingly difficult to deal with title and off-title cleanup.
So what do you mean by title cleanup?
The most common leftover tenancy-related document on title, or instrument as we call them, is a notice of lease. Generally speaking, notices of lease and any linked instruments are easy to delete unilaterally in Ontario, whether as a tenant or as a landlord.
Are there instruments which are harder to delete from title?
Yes, instruments which are more difficult to deal with are those where there is a third party involved, such as financial encumbrances. And the more historical it is, the longer it's been on title, the more difficult it is to remove. Examples are perfected construction liens, charges of lease, or security interests. In these cases, you need to obtain a discharge from that creditor or claimant. Chasing down a historical creditor or claimant can be time-consuming.
And what if that third party can't be found or no longer exists?
We've had situations where the third party has dissolved, so even if we find the successor company, they can't sign a discharge. That party no longer exists. In those cases, we might be looking at a more complex application to delete the instrument or even pursuing a court order.
Where else might we look to see what a tenant may have left behind in the public record?
Requesting information in the records of governmental entities such as the applicable municipality, the fire department, the health department, and the electrical safety authority. These are referred to as off-title searches.
What are the most common messes a tenant leaves behind in these off-title records?
In terms of commercial tenancies, one of the most common issues we see are leftover open building permits. As well, Technical Standards and Safety Authority will keep records of elevator inspections and deficiencies.
So is there anywhere else we should look?
Yes, you can also check corporate records. As a landlord, before you dispose of something a tenant may have left behind, it is important to make sure that a creditor won't come looking for it later. Similar to a security interest registered on title, a personal property registry search can be arranged to identify security interests over the personal property of a tenant, such as specialized equipment.
And what can landlords and property managers do to make sure tenants are cleaning up after themselves?
The easiest thing to do is to require that the tenant clean up after themselves, right as a provision in your leases. If that hasn't been done, arranging these types of searches before a tenant's departure, when you still know where to find them, would be prudent in order to make sure you aren't left with any challenging surprises.
Thanks, Candace. I guess that means we should add public record cleanups to our post-tenancy checklist.
That's a good idea.
That was Candace Cooper in conversation with Jack Sariva discussing tenant departures and public record cleanup. If you would like to learn more, contact Candace on our website, dv-law.com.
This audio recording was a general discussion and should not be relied upon as legal advice.